All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, it shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. The first case on our docket today is Davis versus the state of Florida. Counsel.
Good morning. May it please the court, my name is Lori Wilner. I represent Mr. Alvin Davis, and I would like to reserve 7 minutes for rebuttal. I did nothing wrong. I am not guilty of this crime. I am innocent. Almost immediately thereafterward, the trial court said, your failure to take any responsibility, you still failed to take any responsibility. These comments were a violation of Mr. Davis's right to maintain his innocence. The question before this court is whether failing to take responsibility is a violation of the right to maintain innocence, because that's all this case was about. It didn't involve remorse. It didn't involve lack of remorse. It didn't involve rehabilitation or character. This was strictly about Mr. Davis maintaining his innocence.
Counsel, I'm sorry to interrupt you. Could you be more specific, though, when you say the right to maintain your innocence? What are you referring to? So there's the jury trial right. Correct. Which is not implicated here.
Correct.
There's the right against self-incrimination.
Right.
Right. So how is the defendant voluntarily choosing to make those statements? I mean, how does that violate? I mean, I don't want to put words in your mouth. Can you be which specific right is it that you're saying is violated?
The jury verdict doesn't waive Mr. Davis's right to keep maintaining his innocence. And the reason for that would be Mr. Davis believed himself to be innocent. He had the right to appeal. And there is nothing about the jury finding him guilty that forces him to give up that maintenance of his innocence.
But what's the nature of the right to the right to maintain your innocence? And obviously it gives you a right to plead not guilty and to avail yourself of the right to a trial. He was afforded that.
Yes,
so
Your Honor.
There's been a conviction. He has a choice whether to speak at all at that point, right?
That's true.
So if he chooses to then say what he said, how could you just be more specific and refer specifically to the constitutional text if you'd like, and tell us what right is being violated?
Well, I think the language of the First DCA is what might answer your question. Due process guaranteed Mr. Davis the right to maintain his innocence through all of the proceedings, and this court has said that as well. And the First DCA then said a trial court violates due process by using a proclamation of innocence against the defendant. Then the language of the First DCA said that merely referring to a refusal to accept responsibility doesn't implicate that constitutional due process right. And I think what you're asking is it under the Fifth Amendment? Is it under the Sixth Amendment? I think it's under the Due Process Clause, Your Honor, and under this court's prior opinions that acknowledge that the defendant doesn't have to give up that right at sentencing.
Well, he doesn't have a right to lie. There's not a constitutional right for him to go and give a statement in court that is false.
Well, of course not, Your Honor. He has the right to truthfully. But this wasn't a situation like Mr. Burns where someone made a statement under no oath. I think what this was Mr. Davis, as a layperson, not understanding constructive possession. I think he believed himself to be innocent. And I think that his comment when the judge said, they found you with the gun, Mr. Davis said, they found me with the gun, he did not believe himself to be guilty of possession of a firearm. And so there was no allegation here, like in some of the cases, that he lied. I agree with you that you don't have the right to lie, but that's not what this is. The trial judge is faced with lots and lots and lots of factors in the PSI and many other places, and they consider all of those. But what they can't do is consider something that is the violation of the exercise of a constitutional right. This wasn't a perjury situation.
But the right you're referring to is his right to due process.
Yes,
so he's
Your Honor.
exercising the right to due process. Is that what you're saying? I'm just trying to figure out exactly what the claim is.
Well, I think that's correct. And as this court has said, you have the right to plead not guilty, to go to trial, and to maintain that innocence. What would be the point in admitting your guilt simply because the jury found you guilty if you believed yourself to be innocent? We all know of cases where people have been found innocent later. And
let me ask you this. Do you agree that it's an appropriate consideration if someone shows great remorse for their crime?
well, Your Honor, sure, I think remorse is fine. Of course, that wasn't the case here. I think the problem is when the judge takes into consideration lack of remorse. And I think the reason is...
Okay, so let me explore that with you just for a second. So if your client had come in and expressed great remorse, then the judge could have considered that and given him a lesser sentence because of it.
Yes, Your Honor.
Okay. Now, if your client doesn't come in and show remorse and gets the higher sentence, how is that? I mean, if one is appropriate, it necessarily means that the person that doesn't get the remorse discount is, in some sense, being punished for lack of remorse, whether it's articulated or not. If it's appropriate, wouldn't you agree, if it's appropriate to give a lesser sentence for remorse, then the fact that you don't give the lesser sentence is based on a lack of remorse, whether it's articulated or not. How do you deal with that?
I disagree, Your Honor, for two reasons. One is we use remorse and lack of remorse in the way that you just described in capital cases for aggravating and mitigating situations. We use it in downward departure cases, but nothing gives the individual a requirement to express remorse. In our case, Mr. Davis didn't speak about remorse, and the trial judge never mentioned remorse. The trial judge...
Well, there's no requirement to speak at all, but your
Correct.
client spoke, so...
The trial judge didn't mention that as a reason. The trial judge gave the reason as being because you failed to take responsibility, and that's why I say that what this court has to determine is whether a failure to take responsibility is a violation of his rights.
Let me ask you something else. So you would agree, I think, that under Florida sentencing statute, Chapter 921, the judge, we're not talking about an upward departure. The judge has discretion for any legal valid reason to give up to the maximum sentence on the crime that your client was punished for, correct?
Correct.
So there's no limitation on considering lack of remorse, whether it's articulated or not, in Florida's statutory sentencing laws.
Correct. It's not mentioned.
Okay. So if there is a prohibition against considering it, it does have to be in the Constitution.
Correct.
Okay.
I think this court's opinion in Mitchler might answer this as well. In that case, the individual said they didn't commit the crime, it was someone else. I lost because the alleged victim had money. And this court held that wasn't demonstrating lack of remorse. That was simply that individual maintaining their innocence. And I think that's very similar to what we have here. And as I mentioned, this case was only about maintaining innocence. Remorse wasn't mentioned. So I think that is why the question has to come back to that. And in addition to that case, I think...
Those concepts are similar, right? Or pretty much the same. If you're expressing remorse, don't you have to have admitted having done the crime?
I would think so, Justice Polston, and I'm not quite sure how someone could accept responsibility without admitting that they committed the crime. And if you're requiring them to admit, even after the jury has come back with a guilty verdict, then you're in essence saying your right to maintain your innocence ends at the time the jury comes back with their verdict. I think that...
Or you could just lie at sentencing time and say, I'm now unremorseful, Judge.
That's correct.
Because what happens in trials, lawyers who do criminal defense work, in many instances, tell their clients, you know, I want you to sit there still throughout the entire trial. I don't want you to react to the evidence. And they're doing what the lawyers tell them to do. And this remorse business is not just at sentencing time. The judge is watching them throughout the entire trial to see how they react to the victim's testimony, how they react to witnesses' testimony, and that kind of thing. So when you're talking about remorse, it's an all-encompassing thing. So,
Yes, Your Honor, and I don't think this is the case for this court to really go into when a judge can require a showing of remorse, because that wasn't the basis of the trial court's decision here at all.
But counsel, we don't need to address in this case the situation of someone who really does choose to remain silent, who chooses to say nothing.
Well, unless what you're looking at is whether or not they chose to remain silent on the issue of remorse, maybe I don't understand your question.
In this case, your client chose to speak and said what he said. If someone, you could imagine someone else who says, look, I pleaded not guilty, yes, I was convicted, but I'm going to continue to remain silent and in that sense implicitly maintain my innocence. We don't need to address that situation.
Right. I think that if you look at all the factors a trial judge can consider at sentencing as a pie chart, I think the blue is the majority of that circle, and that's everything the trial judge can consider. I think there's a plethora of reasons that the trial judge can consider. I think there's a small slice of that pie for constitutional violations and a small slice for statutory violations. And in no situation has any court said that a trial judge can violate an individual's due process rights at sentencing.
does the thinking change if the defendant said pleads guilty?
Sure.
And there's a sentencing hearing later on. And can the judge at that time during sentencing say, I haven't seen you show one bit of remorse about what you did throughout the whole thing? After a guilty plea, can remorse be brought up?
Well, obviously that's not our case, and like I said, I didn't really go into remorse that much, and honestly I don't know the answer. In my personal opinion, you've accepted responsibility, so is there a next step that the judge can take and require remorse? I don't think so, and the reason I say that is because what this court has said about remorse in capital cases. It's a negative emotion. How do you require it? Yes, that person has given up some rights by pleading guilty, but how do you require, how does the government require somebody to feel a certain way? How does the government compel you to believe a certain way? I just don't see that could happen.
Well, it's not a matter of being compelled. It's a matter of whether you evidence it or not. And then there are consequences that flow from that.
In some situations, of course.
But the idea that that a sentence might not be more harsh if a defendant has, but just this extreme case, the defendant pleads guilty, and then at sentencing, he stands up before the court and tells the court, I did it, I know it's a crime, I'm not sorry I did it, I'm glad I did it, the victim deserved it. And you're saying, if I understand you correctly, that it would be inappropriate for the trial court to consider those expressions.
Well,
Is that what you're saying?
Not necessarily, because I think...
But maybe, okay.
No, what I think is a lot of it depends on how it gets injected into the proceeding. If it's the defendant who brings up that issue, obviously the trial judge doesn't have to ignore that. However, if the defendant said, I'm a white woman and, we just don't get good sentences in this court, the trial judge can't say, you don't take responsibility, and you're a white woman, so I'm going to max you out. So we all agree there are things the judge can't consider, which is why we go back to whether, if it's a guilty verdict and not a plea, the trial judge can consider the right to maintain your innocence.
My experience in this whole remorse business has been in cases involving DWI manslaughter, where you have a drunk driver and he or she kills someone, and they plead guilty, and those are truly sad cases. And you had someone who was just killed for no reason. The family's crying. The defendant's family crying, begging, their children begging, please don't send my dad to prison, and so on. Those are the saddest cases. And there are cases where there is a lot of remorse shown, and there are some cases where they show no remorse. And then they get a heavy sentence, then in a motion to reconsider sentence later on, the defendant takes a stand and says, my lawyer told me just to play it straight. I was dying inside. I wish I could have told you. What I was told by my lawyer, just play it straight. Don't react. Don't do anything. Those are the situations you're dealing with here. And that's been my experience with it. But here, what the judge said, we're talking about a possession of a weapon, but you still fail to take any responsibility for your actions. That goes beyond remorse. I mean, that's just the judge basically wanted him to say, I'm guilty, I did this.
Yes,
and your
Your Honor.
client is saying, I don't think I possessed that gun. It was in a glove box somewhere. I didn't know it was there. Whatever. The judge is saying, until you tell me you did this. So under that concept, no one could ever be not guilty.
Well, and if you think about the right we're protecting is his right to plead not guilty and to continue with that belief. If you're sitting in that courtroom and you see somebody convicted by the jury, and then the judge says, you fail to take responsibility, that person's going to think, oh, the only way I can do this is to plead guilty. I don't have a right to go to trial, or I'm going to be punished for it. And I think that's a logical conclusion from the comments that were made here.
Counsel,
You have now exhausted more than half of the time you reserved for rebuttal. You can continue or save it. Or if there's a question.
I'll save it. Thank you.
Good morning, and may it please the court. My name is Ben Hoffman. I'm from the Attorney General's office, and I represent the state. When a defendant chooses to allocute, there is no constitutional or statutory prohibition on a judge considering what he or she has to say. In this case, after this petitioner was found guilty of being a felon in possession of a firearm, he made a conscious decision to allocate at a sentencing hearing. And during that allocution, for approximately 3 pages of transcript, he said so much more than I'm innocent, I didn't do it.
What happens if the defendant says nothing, just stands there, no remorse, cold? Can the judge then say, you have refused to show any remorse?
Are you asking if he says nothing at
If
sentencing
he says
at all?
nothing in sentencing.
Then I think we're talking about a situation like Green and Allen, where you're inferring a lack of remorse from silence, and that's not the position I'm taking.
Well, we're going to write an opinion about remorse here.
Well, right, you are going to write an opinion, but this court doesn't have to address whether lack of remorse or failure to take responsibility can be inferred from silence, because in this case, the defendant chose to speak.
Well, what's the
and
answer to his question? What's Justice Labarga's question? What's the answer?
The answer, quite candidly, is it would depend on the circumstances, but if you just have no other circumstances, a defendant who chooses not to testify at trial doesn't show any reactions or doesn't have a demeanor that demonstrates a lack of remorse, and it's just coming from silence, then no, I don't think you can infer it from just that.
So in such an instance where you have a person who has a personality that doesn't show any type of emotion, we all know people like that, I guess, and the person takes that position during the trial and sentencing, despite the fact that you're hearing the saddest stories in the world, and he or she just stands there without any emotion, says nothing, The judge comes out and says, you have still failed to take responsibility for your actions. What should we do?
In a case like that, the state is not asking that this court, affirm, whatever sentence comes after that statement.
You're here to argue about the facts of this case,
Right.
not the facts of other cases.
Right, exactly.
That might come up one day.
Let's talk about that hypothetical, because I think it bears on this case. What, in that instance, is it constitutionally permissible for the court to max out a sentence?
If they are relying on an impermissible factor, so in that case, if you are inferring a lack of remorse from nothing but the exercise of the right to remain silent, then no, it's not a legal sentence, because in that case, you are relying on an impermissible factor under the facts of that case.
So what you said in this particular case, because the defendant did speak up, and the judge basically didn't believe him when he said, I did not know there was a gun in that car, or he believed he wasn't in possession.
Right, and the judge doesn't have to believe him. There's no requirement that, just as any witness takes the stand in a jury trial, a jury could believe or disbelieve any or all of the testimony. At sentencing, a judge is certainly free to accept or reject anything a defendant says, so he doesn't have to find it genuine.
Of course, the reality is the judge could just sit there
Right.
and observe all this and then say, I'm giving you the maximum sentence without elaboration, and that'd be the end of it.
Right. So in this case, the judge could have said, Mr. Davis, you've been found guilty by a jury of your peers of possession of a firearm by a convicted felon. It's a second-degree felony. I hereby sentence you to the maximum, which is 15 years. And there'd be no way to attack that on appeal.
Right.
Obviously,
So it just depends on, the only reason this comes up is if the trial court, the sentencing judge speaks and talks about the court's reasoning process. There's no requirement that the court give a justification for a sentence that is up to the statutory maximum. Now, they've got to give justification for downward departures. But isn't that correct? And the trial court could just sit there and as you said, just impose the sentence, and that'd be the end of it.
That's correct. So under the current criminal punishment code, a judge could just, as you said, just sit there and say nothing, hear argument and say, I hereby sentence you to the maximum, or I hereby sentence you to 15 years. Obviously, I think from a policy standpoint, we would like judges to be transparent in their thought process. I think in the U.S. Supreme Court case of Grayson, I think that trial judge, said, specifically, out of fairness, I want a reviewing court to know what my reasons are. So I think from a fairness standpoint, we do want to encourage judges to be transparent. But yes, under the current state of the law, a judge could sit there and say nothing more than, you've been found guilty, I sentence you to the maximum. And that is a legal sentence, can't be attacked on appeal.
So how then could you have a situation like this where a defendant is found guilty by the jury and then comes to sentencing, and by a silence or a lack of, to affirmatively express remorse or to admit guilt through that process, then be subjected to a harsher penalty just because of maintaining a silence about admission of guilt? Why is it that an unconstitutional violation?
Well, Justice Polson, the question, I think, has a premise of it assumes that the judge went up from a baseline sentence that we don't know. So I guess the two possibilities are, in this case, the judge could have, after hearing the number 15 from two different sources, the judge could have already had 15 in his mind, and then after the defendant spoke, said, you haven't given me a reason to come off of 15. And I think everyone's agreed that that's permissible for a judge to decline to go down based on a lack of remorse. The other option, or the other possibility, is the judge had a different number, we'll say 12 years in his mind, didn't want to go along with the 15, wanted to give something a little less, and then heard the defendant speak, and then decided, well, you haven't taken responsibility, you haven't shown remorse, so I'm going to add 3 years to what I was going to give you before. We don't have a baseline to know what happened in this case.
But isn't he really being punished for not speaking in a way that the judge is requiring him to speak about taking responsibility or showing remorse?
Well, but in this case, the judge didn't require him to speak at all. But in a case,
he's being punished by not admitting it.
Okay, well, Well, then if we take the case of a downward departure, for instance, where everyone agrees it can be used to downward depart, if a defendant asks for a downward departure and doesn't show remorse, I mean, I don't think we would say he's being punished if the judge says, well, I don't think you've shown remorse, so I'm not going to give you the downward departure.
It seems different to me that, on one hand, if someone expresses remorse, an admission to express remorse, then to consider that as a mitigation and a reduction of sentence. But on the other hand, somebody who is maintaining innocence thinks that they have a possibility that they're going to get this turned around on appeal, or maybe get a new trial, and someday be found innocent. It happens. So why are they then subjected to a harsher sentence for their requirement to say they're guilty when they don't think they are?
But it's so. But I disagree that this is a case where the trial judge conditioned the sentence on him admitting guilt. And this is a case where he said a lot more than "I'm innocent, I didn't do it." He went on for 3 pages where he came up with this very elaborate conspiracy where just about everyone in the courtroom was out to get him, accused his own lawyer of selling him out, accused the witness of lying, accused the police of putting the witness up to lying, didn't even really spare the trial judge by essentially saying that he let all this go on.
Basically, it was a tirade against the whole system.
Right.
I think is a fair way to describe what happened there.
Right.
And, he can say what he wants to, but that's what he said. It was a tirade.
Right. He chose, so a defendant certainly has a right of allocution at sentencing. They obviously have the right to remain silent as well. And really the decision of whether to make that allocution at sentencing is really a decision that's no different than a defendant facing the decision, do I testify or do I not testify in front of the jury? If I choose to testify, the jury can use what I say against me. It's really no different in the sentencing context. I can choose to speak up and maybe seek a more lenient sentence, or I could choose to remain silent and just understand that if I choose to speak at sentencing, what I say might be used against me.
So the rule is that if a defendant speaks at all at sentencing, then they have to admit guilt. They have no right to maintain innocence, or they're subjected to a harsher sentence. Is that the rule?
Well, in some other courts, that kind of is the rule. Not necessarily admit guilt, but there are many other jurisdictions where the right of allocution is recognized and where trial judges are given discretion if a defendant strays from what is understood to be the bounds of an allocution. The judge, for instance, can cut them off and say, that's not what we're here for. We're not here to argue innocence. That was the trial phase. We're here for sentencing. So I actually don't agree that in an allocution that a defendant does have the right to argue innocence. Florida courts have been remarkably silent on that. I don't know if that's intentional or not, but just about every other jurisdiction that recognizes the right of an allocution has made clear that defendants don't get to just say anything and everything, and many of them specifically note that a defendant does not get to argue innocence during an allocution because that's not the point of an allocution.
Is there anything textually different in the Florida Constitution from the federal that would justify or require us to have a different standard than the federal standard on this?
No. So as I understand it, the only way that this possibly fits within a constitutional framework is if we go under the Due Process Clause. And looking at the federal Due Process Clause versus the Florida Due Process Clause, I don't see anything that would require Florida to have a different standard.
If you owned a store and I walked into your store with a 30% off coupon that I had clipped out of your advertisement and got a 30% discount, and Justice Polston comes behind me and walks into the store and doesn't have the coupon card, would he be justified in complaining that you are punishing him for not having the coupon?
No, I don't think so.
Me for taking the time to clip the coupon, correct?
That's correct. So you've gotten the discount for having the coupon. Okay. The person behind you doesn't get the discount for not having the coupon.
And both parties agree that a show of remorse and taking responsibility in this context is essentially a valid coupon, correct?
That's correct.
And I'm still struggling to understand why, if there's a case where remorse is could change. I mean, there are certainly cases where it doesn't matter. The circumstances of the case and the prior record are such that remorse wouldn't make a difference. It would be a max sentence, perhaps. But in a case where remorse would make a difference, where somebody could walk in with that coupon, that if they don't, that you could say that you're punishing them in the same way that you could say you're punishing somebody for not having a coupon because they don't get the discount. But I mean, that's sort of what you're arguing, but I'm just still struggling with the fact that once you accept remorse as an appropriate sentencing consideration, whether it's articulated or not, if someone does not get that reduced sentence for a show of remorse, whether they've allocated or not, they are essentially getting a greater sentence because they did not show remorse, correct?
Yeah, that's correct.
Okay.
They are getting the greater sentence for not showing remorse. But the other part of that, though, is, I mean, if remorse or responsibility are truly impermissible factors, there shouldn't be an up or down distinction at all. So, for instance, everyone agrees race, religion, national origin. Everyone agrees those are impermissible factors. There would be no up or down distinction. I think the Nawaz case out of the First District was a religion case. So, we wouldn't accept a scenario where a judge says, you're a good Catholic fellow as I am, which I think was actually the facts of one of the cases in the briefs. You're a good Catholic fellow as I am, you're going to get a lesser sentence. Or you haven't disavowed Catholicism, which I'm against, you're getting a greater sentence. I mean, we wouldn't have an up or down distinction, because if it's truly impermissible, you can't consider it at all. Remorse or responsibility is the only factor that appears to be able to work one way and not the other way. And from a policy standpoint, it doesn't make sense from a policy standpoint, and it's really unworkable because if you don't.
What happens if you really are not guilty? If you did not do it, you did not do the crime, you're found guilty, and you choose to tell the judge, I did not do this because I'm innocent.
So, if those are the only words spoken at the sentencing hearing, I think it's a closer call to judicial vindictiveness.
Well, I mean, you do agree that people have been exonerated in Florida after being found guilty, actually being on death row.
I didn't know about the death row part, but I do know that people that have been found guilty that are innocent end up being cleared later.
But that happens.
Right.
So, I guess what the suggestion here is, if you're not guilty, the jury finds you guilty for whatever reason, you approach sentencing, your lawyer's going to tell you, this judge is a hard sentencer. You better tell him you did it, you're sorry, you feel horrible. Lie. If you don't want to get the max.
But the other part of that, though, and we haven't addressed it yet, is the standard of review and basically how you determine, assuming it's even error to start with. So let's, for the sake of argument, say it's error. Not all errors are going to be reversible. So the second part of the inquiry is how do you determine if it's reversible error? And nobody has addressed the standard of review yet. But
you would agree that if it is a due process violation, it would be fundamental error. And there wouldn't be a harmless error test.
Well, I agree. It's not.
I mean, if it's an inappropriate sentencing consideration, and that consideration is made just like any other constitutionally inappropriate sentencing consideration, then it would be a reversal for sentencing before another judge.
Well, I don't agree with that. And even the district courts up to this point, all 5 of them, even though I think they have, I guess for lack of a better term, butchered the standard of review, even all of them agree that just because, even in the context of a lack of remorse case, it's not automatically reversible, and they have this test of whether they can...
if you can tell for certain that the same sentence would have been given, then there's...
Right. So basically, does it affect the sentence?
Right.
Is part of that fundamental error analysis. So the problem with what the district courts have been doing is, one, they've been essentially requiring, even in an unpreserved case where we should be in fundamental error land, they've been requiring the state to demonstrate that the error was harmless and for the state to demonstrate why reversal is not warranted. When a comment is unobjected to and it's not preserved, it's always been understood in every other context that it is a defendant's burden to show why, basically to demonstrate fundamental error. And in the sentencing context, there's a qualitative component and a quantitative component. And the quantitative component, I think the district courts have been missing out on. And for the quantitative component, basically you have to show that the sentence was somehow affected by this factor. And that's why I was trying to get at, we don't have a baseline to know whether the judge permissibly declined to show leniency or impermissibly decided to go up. We don't have that. We don't know what the judge did. So under the fundamental error standard, it's the defendant's burden to demonstrate which one of those happened. And since we don't know, that really by itself, in this case, should require an affirmance, even if you don't want to hold that lack of remorse or lack of responsibility, failure to take responsibility or permissible sentencing factors. If nothing else, because they can't demonstrate and haven't even attempted to articulate a test for how you would determine whether the judge permissibly declined to come off 15 or impermissibly chose to go up to 15, we don't know. And if nothing else, I think the court should clarify what the proper standard of review is to the district courts when a sentencing error like this is unpreserved, and it should be fundamental error, and the state shouldn't have a burden.
One other thing, would you agree that if it is a due process violation to consider lack of remorse or lack of not taking responsibility for your actions, then it would seem to also be a due process violation not to give the defendant the same sentence that he would have gotten if he'd taken responsibility by a plea?
Well, Justice Lawson, I don't agree with that, just because in the context of plea bargaining and generally, I mean, the U.S., I think this court has as well, but certainly the U.S. Supreme Court has acknowledged that we are a society that encourages guilty pleas, and the government can certainly, or the state can, encourage someone to plead guilty by offering a sentence that would be less than what they would get at trial. So, for instance, having been a prosecutor myself before coming to the Attorney General's office, in a case, say, a drug minimum mandatory, where they would be looking at a 3-year minimum mandatory sentence if they were found guilty at trial, the state can certainly waive the minimum mandatory in order to get a defendant to plea. Even without a minimum mandatory, the state can certainly encourage a guilty plea by offering to downward depart. That's one of the bases for a downward departure, a legitimate, uncoerced plea bargain. So just because the defendant didn't plead guilty, goes to trial, and then gets, say, the minimum mandatory, I mean, I don't know that we would say he was unconstitutionally punished for that.
Right, and that's his point. For the same reason that's okay is the reason
why
it's
okay.
okay.
I misunderstood you, so I'm sorry. But yes, right, we wouldn't say it's an unconstitutional punishment.
I mean, the law is well settled that it's not a due process violation. But couldn't you also describe that as punishing the defendant for not taking the plea?
Yes.
I mean, he gets a greater sentence. He didn't accept responsibility. He didn't take the plea. He's getting a greater sentence. I mean, the fact that that's as clearly established as it is not being a due process violation, I just would think that the same.
Right, and the U.S. Supreme Court, I think, has actually said that you are being punished, but you're not being punished in any way that the Constitution prohibits. Right. And I see that my time is expiring, so if there are no other questions, that concludes my argument.
Because remorse was never mentioned by the trial judge in this case, the only way I can interpret the First DCA using that language is interchangeably with maintaining your innocence. And if you have a right to maintain your innocence, then you have a right not to express remorse. I think the most important thing that I didn't say in my initial argument was we should believe trial judges. We need to believe them. The judge in this case told us what he was considering in this sentence, Mr. Davis's record, the fact that he had a firearm, and he said not once but twice, you still fail to take responsibility. If there are no further questions.
But would you also agree to the point that opposing counsel made that we don't know whether the judge thought that a 15-year sentence was appropriate unless remorse was shown, or thought maybe a 10-year sentence was appropriate, but now I'm going to punish you because of you didn't express remorse. I mean, we have no way of knowing which of those two is true. So we don't know whether consideration of lack of remorse made a difference in the length of sentence.
Justice Lawson.
As a punishment, an upward.
Yes, we don't know that, but that is somewhat irrelevant in a situation where the right we are protecting is not the right to a certain length sentence, but the right to be sentenced based on permissible factors. And that's the harm that was done here to Mr. Davis. His sentence was based on the impermissible consideration of his right to maintain his innocence. And because of that, he should get a new sentencing hearing before a different judge.
But counsel, you keep saying the right to maintain innocence. And show me in the Constitution where it says that. Obviously, you have a right to a jury trial. Your client got that. Now we're talking about whether he chooses to speak at sentencing, and if so, what he chooses to say. What is the right to maintain innocence that you're referring to?
I'm referring to the due process right. Similar.
Textually, can you tell me what the words are that it says?
I don't have the 14th Amendment or this state's Constitution.
Is it the right not to be a witness against yourself?
No.
I mean, that's what the words in the Constitution.
Right. But in this situation, I'm sorry.
Go ahead.
In the Florida Constitution, I would say it's Article 1, Section 22, and added.
Which says what?
The right to plead not guilty and to go to trial. But added to that would be this court's interpretation that right carries all the way through all of the proceedings. And the First District nor any other district in the state disagrees with that. The First District just says, yes, you have the right to maintain your innocence, but a failure to accept responsibility has nothing to do with that, and that's where we disagree.
So if I understand your argument, if the trial judge had said this, what I'm about to say at sentencing, you would think there was a due process violation. And this is what the trial judge says. I've looked carefully at your prior criminal record, and I've considered the facts of this case. I've heard all the testimony, and I think that a 15-year sentence, a maximum sentence, is appropriate in this case, given those two factors. Now, if I thought rehabilitation was possible for you, I might consider I would consider a rehabilitative sentence. I think maybe 5 years in probation. But since you aren't taking responsibility, I don't think rehabilitation is appropriate, and so I'm going to give you the appropriate sentence based on your criminal history and the facts of this case. That would be a due process violation.
Well, I don't really understand how rehabilitation would be relevant where the client didn't ask for a departure sentence, and we're looking at a sentence between 10 and 15 years.
Well, I mean, I think in the briefing, and most folks consider lack of remorse an appropriate
I see what you're
consideration,
right.
Because that indicates taking responsibility as the first step in rehabilitation.
I don't think that rehabilitation opens.
Okay, forget the rehabilitation.
Okay, remorse.
I would give you a 15-year sentence just based on your history and this. If you'd shown remorse, I would have reduced it, but you didn't. Would that be a due process violation?
Yes, Your Honor. And this sentence would have been improper if Mr. Davis had said nothing. I realize the state believes that it's even more proper because of what he said, but that's not the law. The law is that he had that right. That's what he was doing based on what this court has said in the past. He was maintaining his innocence. He believed himself to be innocent. He said exactly what
the state has conceded. It would be, if I understand correctly, that it would be a different case if he had said nothing. And that's not, they're not arguing about it. a different case where the defendant said nothing at the sentencing, right?
Yes, Your Honor, but I think that when Mr. Hoffman spoke to that, I think it was an answer to the question of whether or not lack of remorse can be inferred from silence. What I'm saying, because remorse isn't part of this case, what I'm saying is the trial judge erred in taking into consideration his constitutional right to maintain that innocence, even though the jury came back with a guilty verdict.
All right, counsel, you're now 2 minutes over. If you could sum up quickly.
Thank you.
Well, I mean, the clock's been running. You've been.
We would just ask that you reverse the opinion of the First DCA and go back to the test that's been the law in Florida for nearly 40 years, and that is whether or not the record can be read to reasonably show that the trial court relied on an impermissible factor. Thank you.
We thank you both for your arguments. Now move to the second case on